Good morning, everyone, and welcome to our discussion on provisional measures today in international law. I'm Farah Barnashawi, affiliated with the Sorbonne in Paris and part of ICTIG's, the International Courts and Tribunals Interest Group's Advisory Board. I am delighted to be your moderator, and thank you for joining us. So throughout the next hour or so, we are going to unpack provisional measures before the International Court of Justice, or the ICJ. In recent years, perhaps even more accurate to say months, we've witnessed a marked increase in incidental proceedings, with states turning to provisional measures more and more as a tool in their legal arsenal. So to give you but a few numbers, between 2001 and 2023, the court issued 54 provisional measures in 15 cases. In 2024 alone, there were 6 requests for provisional measures, and we're still not done the year. So this trend not only underscores the importance of revisiting the fundamental principles governing provisional measures, but it also invites us to consider broader implications, particularly in cases where political undercurrents are at play. So our conversation today will explore these issues from multiple angles, and our distinguished panel is going to guide us through the complexities of this topic, from their purpose and procedural nuances to the role and mandate of the ICJ, while touching on the growing engagement of states from the global south, a development that has added new dimensions to the landscape of provisional measures. So without further ado, I'm going to introduce our panelists, each of which brings a wealth of knowledge and unique perspectives. First, Amir Farhadi, Associate in Public International Law and International Arbitration at Foley Hoag. Cecily Rose, Associate Professor at Leiden University. Aranj Toger, seasoned litigator and consultant in international law and adjunct professor at Brooklyn Law School. And last but not least, Ona Hathaway, professor of international law at Yale Law School. So we will allocate a few minutes at the end for Q&A. You can use the Q&A functionality on Zoom. And with that, let's dive into our conversation. So Aran, I'll start with you. Can you elaborate on the purpose and procedural requirements of provisional measures and if they've evolved at all over the last few years?
Sure. Thank you, Farah, for having me on this panel, and good morning, everyone. Both the purpose and the requirements for the imposition of provisional measures have evolved over time. Now, the starting point is Article 41 of the ICJ statute, which reads, "The court shall have the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party." And that's all the statute says. Now, preserving the rights of the parties refers both to the applicant and the respondent. So this entails a balancing act between the sovereignty of the respondent and any irreparable harm that may be caused to the applicant pending final judgment. Now, the court has also asserted in its jurisprudence that it can issue provisional measures in order to prevent the aggravation of a dispute. And an underlying consideration both of the preservation of rights and avoiding aggravation is the integrity of the judicial process itself. So also the protection of the court itself. Now, a pivotal moment for provisional measures was the Legrand case in 2001, where the court for the first time stated that provisional measures are binding on the parties. And if provisional measures are binding, their imposition, of course, is more consequential. And so the court has since developed a set of requirements to be present for the imposition of provisional measures. And these are prima facie jurisdiction, a causal link between the measures and the rights to be protected, risk of irreparable harm, which was the primary test in the court's earlier jurisprudence, and plausibility of the rights claim. Now, I'll just take a moment to talk about plausibility because it's the requirement that causes most confusion and controversy. What does a finding of plausibility actually mean? Now, the reason for the lack of clarity, I think, is because the court is yet to provide us with a clear definition of what plausibility is. And this is something that, for example, Judge Ad hoc Kress noted in Gambia v. Myanmar. Judge Iwasawa recently said that plausibility is a test aimed at examining whether it is plausible that the rights asserted by the applicant exist under international law. Judge Bandari says that plausibility means that the rights invoked are not manifestly unfounded. So the claim itself is plausible. These are examples of two fundamentally different approaches. The first focusing on whether the rights claimed exist, and the second on whether the claim of a breach with underlying facts is plausible. In South Africa versus Israel, the court found, and I quote, "At least some of the rights asserted by South Africa under the Genocide Convention are plausible." And what does that mean? Some took it to mean that the court has found that it's plausible that a genocide is being committed. On the other hand, Judge Donahue, after her retirement, in an interview for the BBC, said that the court decided that, and I quote, the Palestinians had a plausible right to be protected from genocide, and that South Africa had a right to present that, to the court. So these are two very different approaches to plausibility, and we can see that they have very practical implications. And I'll leave it at that.
Thank you very much, Aaron. That was a very good kind of Kickstarter to what provisional measures are, which allows me to turn to you, Ona, with respect to cases where provisional measures intersect heavily with issues related to the use of force. What factors do you think the ICJ should consider to ensure its decisions are both legally sound and diplomatically sensitive?
Yeah, thank you for that question. I mean, I think that this is in many ways a kind of critical question facing us in the cases that are sort of most prominent in front of the court today. So there are some who would say it's not the role of the ICJ to pronounce on these questions, that use of force is sort of a fundamentally sovereign determination, that it is one that the ICJ should not intervene on, and particularly with provisional measures where it hasn't done the kind of full briefing of both sets of parties and made a complete determination as to the underlying facts. And I will just say that I don't think that is the right way to think about it. Look, these are critical. The question of the use of force is in many ways the critical international law prohibition. And use of force decisions are ones that there's no real other forum to address these issues. So the ICJ plays a kind of unique role in the international arena in making determinations, at least when it comes to the legality of the use of force. That said, these are areas where I think the court is, as I observe these most recent cases, trying to feel out what it can and can't do. It doesn't want to destroy its own credibility by making pronouncements or ordering the parties to act in certain ways that then they just completely ignore, and then making obvious the sort of incapacity of the ICJ to act and to render decisions that are going to be followed by the parties. On the other hand, for it to ignore these issues is really to be blind to the critical underlying issues. So let's just talk about a couple specifics, and then I'm curious to see if my co-panelists have different views on this. But if we look at the Russia v. Ukraine case, the provisional measure stage, it's really interesting there that effectively the court was willing to kind of stick its neck out and accept a quite forward-leaning argument by Ukraine that Russia's allegations that Ukraine was engaging in genocide was one of the justifications that was used for the Russian invasion of Ukraine, and that therefore the ICJ should find both that is an illegitimate use of the Genocide Convention, and that any allegations of genocide are not sufficient to justify the invasion. And at the provisional measures stage, the court entertained that, and in fact ordered Russia not to cease the illegal invasion, to halt all of its ongoing military intervention, on this quite forward-leaning and distinctive argument that Ukraine had made. And then when it came to the next stage of the case, they seemed to sort of back away from that. They declined to actually entertain that argument, and decided instead only to proceed with the case on the question as to whether Ukraine had in fact engaged in genocide, and not address this question as to whether the intervention is lawful or not, the Russia's intervention is lawful or not. Now, in a way, they're still determining that, because if they determine that Ukraine in fact was not engaged in genocide, then obviously any false allegations of genocide would not be a justification for use of military force in Ukraine. But I think what I see the court doing there, and again, I'm interested to see if the co-panelists feel the same about this, is I think the court is recognizing the limits of its own authority, and and it recognized that when it made the determination of the provisional measure stage, it had zero impact on the ongoing war. And moreover, to the extent that it thinks of the enforcement of its decisions as coming not just from the Security Council, because of course the Security Council is never going to enforce any orders against Russia, given that Russia has a veto. They, I think, also recognize that any state that was going to put in place sanctions or otherwise engage in sort of third-party enforcement of its decision were already doing so. They're already participating in extensive sanctions, both economic and diplomatic. And so it's not, if the court was to sort of stick its neck out, it wasn't going to change really anything on the ground. And so I think they backed off. I mean, interestingly, in the South Africa v. Israel case, the court has also been confronted by the same set of challenges, and it's been a little bit more cautious here. It was initially reluctant to weigh in on the question of ceasefire. It has become more forward-leaning on the question as to whether whether ceasefire is necessitated, and in fact, in its most recent ordered ceasefire, but was sort of limited in terms of exactly what it was saying, and there's been sort of confusion as to exactly what it was and what it was ordering Israel to do it and not to do. There, I would read that as in part the court thinking, well, maybe it could make some difference on the ground if it leans in to making a decision about the lawfulness of the use of military force by Israel, because there are a number of states that might change their behavior with regard to Israel if they believe that the court is saying that it's legally obliged to engage in a ceasefire. But it has come under a lot of criticism for that. And it's come under criticism in particular for what some perceive as inadequately weighing Israel's right of self-defense. Now, of course, Israel has made arguments along these lines. So I think the court is, trying to figure out its own political space here and trying to figure out where it can be forward-leaning on use of force issues. And I think that it should, I think it should continue to play a role here, but I think it also does have to manage its own credibility and legitimacy. And I see it trying to figure that out in these cases. But I hope that it doesn't learn the lesson that it shouldn't weigh in on these issues, because honestly, if it doesn't weigh in on these issues, who will? And who is an authoritative actor to make decisions, even if those decisions are going to be largely ignored, maybe it's nonetheless important for them to make them. So sorry, that's more than I meant to say, but important topic.
No, absolutely. Very, very insightful as well. And I think maybe before, Amir, before I ask you the next question, it would be interesting to kind of open it up to you panelists to react to maybe Una's intervention. What do you think? What do you make of the ICJ being forward-leaning with granting provisional measures, but kind of sometimes stepping back on the merits phase?
I have a brief comment here. I think that it also really serves as an illustration of the fact that prima facie jurisdiction really is prima facie. So it's very possible, in other words, that the court, upon more thoroughly examining the issue and on the basis of much more argumentation from the parties, comes to a different conclusion. And we've seen that now, not only in Ukraine, Russia, but also in Georgia, Russia. And I understand absolutely how that happens. And then the same is true for evidentiary matters. So I think that the kind of evidence that can be presented by parties at the provisional measure stage on genocidal intent is necessarily going to be much more limited than what you'll see at the merit stage. And that, of course, goes back to the issue of plausibility and the extent to which the court should or ought to delve into evidentiary issues regarding genocidal intent at that stage, at the provisional measure stage.
Yeah, absolutely. The threshold at the merit stage is much, much higher than the provisional measure stage, which could also be part of the explanation.
I would just add one brief thing. Sorry. I think it's also possible that the judges themselves sometimes get a little swept up by the politics surrounding the case. And then as the months go by and they view the case with a broader perspective, and on the basis of indeed more evidence and more legal argumentation, they come to different conclusions.
Yeah. Just on that last point, there's of course a sort of famous separate opinion in the Ukraine-Russia genocide provisional measures by a judge who really kind of acknowledged that there was a political element to it. And I think that when you see these things play out, especially the use of force things that Una has discussed, you see them really trying to walk the line between the sort of political aspects of their role as this body composed of 15 individuals from all over the world, elected by political organs of the United Nations, having a degree of a political function around them, but also their role as judges of international law. And I think the way you saw, for example, with South Africa, Israel, of this incremental sort of increase in how far they were willing to go, I think reflects that balancing act exercise from a practical standpoint. And also I would add to what Una said, which is that not only, of course, was there a perception or pressure, let's say, to have a deference to Israel's claimed right to self-defense, there was also pressure, I think, from the street of the global South to go the other way. And so they were almost caught in this position of damned if they did, damned if they didn't. And you felt that in the way that they tried to sort of thread the needle, I think.
Well, then I'll chime in as well. I think the one place where I would slightly differ from Una, not so much on the principle, but I just wish the court would have thought ahead in Russia, Ukraine v. Russia, for example, as to what eventually it will probably likely do at the preliminary objections phase. Because if you read some of the separate opinions on provisional measures, you already see some of the judges acknowledging this is not really a dispute about genocide. And so I think in retrospect, Ukraine, it was a bit of a waste of Ukraine's resources and a bit of a little stain on the court's credibility, which could have been avoided. And of course, everybody knew Russia would ignore an order anyway. I just add one point that I think these types of issues, you could look at it either way, whether the court got it right at the initial stage and then got it wrong by backtracking or vice versa. But I think these types of issues are more likely to happen in cases where there's a tension between the jurisdictional basis for the case and the events on the ground. So when there are serious violations of international law or violations are alleged, whether it's in Ukraine v. Russia, where the real issue is use of force, South Africa v. Israel, where I think in any event the main issue is IHL, you're going to have these tensions between the jurisdictional element, which is based on a different convention, the Genocide Convention, and how do you then take that and deal with reality on the ground. So I think that's, in these cases, perhaps it's just coincidence that they're about use of force that you'll see these problems, I think, surface to the greatest extent.
Yes, absolutely. And I think just going back to Amir's point on states from the global South and the court kind of being stuck having to respond using a very delicate balancing act. I mean, it brings me to my next question to you, Amir. I mean, what do you think is driving this type of increased engagement from states coming from the global South? And how do you think this type of engagement influences broader dynamics of international law?
Yeah, well, thank you, Farah, for the question, which I think is super interesting to pinpoint the global South role. Just a couple disclaimers, of course. Obviously, I'm speaking in my personal capacity, not on behalf of my law firm or any clients. And also, I should say that I'm not obviously a designated spokesperson of the global South, which is not by any means a monolith. And I tried to put together actually some statistics pertaining to the Global South and the ICJ provisional measures recently, which of course meant that I kind of had to try to define the Global South, which is also a difficult thing to do. But what I did was I basically excluded the sort of the WEOG, Western European Others Group of the United Nations. I also excluded European Union members that are not part of the WEOG group, and also P5 powers, because I think that in the context of the United Nations mechanisms, regardless of whether they have Global South connections or would be perceived as Global South, like China, they're still wielding that P5 power. So with those parameters in mind, I looked at the past 10 years, which I noticed earlier, Farah, you went back about 23 years and you got to about 50 cases. In the past 10 years, 26 orders have been granted by the court. 15 of those in the past 3 years alone. So we really have gone from an average of 1 or 2 a year up to almost 5, 6 a year. And in this, I sort of also counted, of course, requests for modification and orders that were issued when there was not, when the request was withdrawn. And the statistics are really interesting. So in those, you have about 10 South-North cases, so Global South states suing or requesting provisional measures against Global North states, 13 South-South, 2 North-South, so the Global North state requesting measures against the Global South state, and those are only 2, really, Canada and the Netherlands versus Syria, and then Australia and Timor-Leste, there was Australia's modification request to have the measures against it withdrawn. So really a small amount. And then 1 North-North, Germany, Italy recently, which was withdrawn. So vast majority, 23 out of 26 in the past 10 years, driven by the Global South. So what then is driving that? I would say there's probably 3 larger trends in international law that are driving this, and we've touched upon some of them already indirectly, but I'd say 2 of them are kind of negative trends, and 1 is perhaps a source of hope. So the first trend, I think, is, and the category of provisional measures is linked to Security Council paralysis, which Una mentioned earlier. You know, it's no secret that when it comes to certain issues, when it comes to the interests of certain states, access to the Security Council just isn't available, whether that's for Ukraine or for Palestine. The situation is the same because there's a veto power that can be exercised by a permanent member. And so what that does is it kind of removes the possibility of having recourse to the Security Council, which is traditionally the only way that a state can bring an urgent situation, a crisis, to the attention of the international community, get its, certain amount of time in the room with the attention of the whole world and examining what the situation is from both a legal and political perspective. Now, we've seen in response to that an attempt by states to essentially convene the global community in The Hague, in the Peace Palace instead. It's not done usually within a matter of days or hours, as with the Security Council, but within a matter of weeks, and usually while the issues are still very much pressing. So out of the sort of 26 that I identified of requests in the past 10 years, I think about 8 or 9 are linked to this Security Council paralysis, where you really see states that would not have been able to sort of get even time in front of the Security Council, or let's say a fair hearing, and certainly no hope of a resolution being adopted. And I think you could even stretch that number from 8 or 9 all the way up to 15 if you count certain situations where lack of interest from the Security Council and some maybe not so obvious veto dynamics, but they're also at play, and I won't really go into too much detail on those situations. Then I'd say the second category that we've seen a lot of is related to this new trend of actio popularis cases being brought before the ICJ, which are essentially situations in which a state, other than the state that is most sort of directly injured, the victim state, another state brings a claim against the state that's alleged to have breached international law on the basis of erga omnes or erga omnes partes standing. And these, of course, usually concern fundamental human rights, international crimes. We've discussed genocide. There are a lot of cases under the CERD. We've seen Gambia, Myanmar, South Africa, Israel, Nicaragua, Germany. I'd say about 6 of such provisional measures requests in the past 10 years, majority South-North, 1 South-South, being Gambia, Myanmar. And I'd say that there are probably 2 themes underlying these. The first is, simply put, the question of double standards. So, if you listen to any statements coming out of Global South states, whether it's in advisory opinions in front of the ICJ, whether it's in the General Assembly, there's an increasing frustration and a perception that there are double standards being applied when it comes to international law, that when the global north has an issue, or certain members of the global north have issues with the respective international law, it's pinpointed and it's called out, and the norms are clearly called, compliance is called for, etc. The opposite is not necessarily true. So you have that frustration, which plays out in these actio popularis requests. And also some of them are not necessarily completely linked to double standards, but could be linked to situations where, they pertain to a sort of forgotten situation on the global scale, on the global plane, and where you don't have enough attention, where the global South feels that there's not enough attention for a certain issue. Gambia, Myanmar, for example. Also, obviously, the global North, Syria, Netherlands versus, Canada, Netherlands versus Syria. And then finally, the third category I would say is sort of the more traditional best customers of the court, which I think come from the global South. The global South states are the ones that are sort of have the largest history of bringing disputes that really fall within the sort of traditional framework of the court, bilateral disputes that aren't necessarily linked to the use of force, that aren't necessarily linked to situations of urgency, but you do see urgent situations crop up in the context of those cases from time to time. And I think that these states will tend to try to almost depoliticize and remove an urgent issue from their bilateral relations and put it in front of the court. India, Pakistan, in the Jadhav case, you had really nuclear powers who could well have sort of elevated this issue up to the highest plane between them, but really they depoliticized it in a way. It went to the court. Recently, you've seen Mexico and Ecuador going to the court. That was almost immediate. So you do see states sort of trying to bring discrete issues that really do fall within the jurisdiction of the court before the court in order to avoid, let's say, overly politicizing the issues. I'll leave it at that.
Thank you, Amir, for this extremely comprehensive answer, and the statistics kind of help put things into perspective. So thanks for that. And kind of building off of your answer with, illustrating really the rise in the use of provisional measures, Cecily, I turn to you to ask you, do you see and what can be potential risks of backlash with the rising use of provisional measures?
Sure. Yeah, so in terms of risks of backlash, what I see as the main problem here is the risk of noncompliance. So I'm referring here then in particular to the case between South Africa and Israel, and also Ukraine and Russia. And what we've seen, for instance, are newspaper articles that report on the provisional measures order, and then indicate what it says, and then indicate in the next sentence that the order isn't enforceable. And then, of course, it becomes very evident as the days and weeks and months go on that indeed the order hasn't had a perceptible or any impact on events on the ground. And the potential there, I think, is that the court's provisional measures orders will simply be regarded as a publicity generating mechanism for the applicant state. and little else, and that they won't be taken seriously anymore. So I'm painting here sort of a worst case scenario that maybe we're seeing the apex of recourse to the court and that it'll decline, and that we'll see states decreasingly bringing disputes, conflicts to the court because they don't expect them to have any real impact on the ground. Now, to try to shift to a somewhat more positive note, I think that there are, in terms of mitigation measures, so to speak, there's not much that the court can do, if we're really honest, about the enforcement of provisional measures orders or its judgments more generally. There are a few small things that the court could do more of, or could change. So the court sometimes asks the parties to report back on compliance with the provisional measures order, but sometimes it doesn't. And so first of all, it often doesn't explain why it's ordering or not ordering reporting back about compliance. And I understand that the court's reasoning in its provisional measures orders is usually relatively limited, but still it would be desirable for that reasoning to be included in the order. And if the court were to not only regularly order reporting back, but also to put the information provided by the litigants on its website, that could also perhaps play a role in bringing about a greater sense that the parties are being watched, not only by the court, but by the press and by the general public. Otherwise, the ICJ president can and has in the past reported non-compliance with provisional measures orders to the General Assembly in its annual report, but it does that only when the case has finished, so at the merits judgment stage. And I, for one, don't see any reason why that couldn't happen on a yearly basis. And that's just a sort of naming and shaming technique. But I do think that that's something that the court could definitely consider changing in terms of its current practice. So those are my thoughts for now on the enforcement problem and the limited tools available to the court to address this issue.
Thank you, Cecily. And the enforcement problem is an important one because it also kind of shifts now my question to Iran on with this rise of provisional measures, this pressure on the court to give out these orders. Do you think it has affected its overall workload and decision-making process to be granting these orders?
Well, thanks, Farah. That's a very good question. I don't know that I can answer it to the fullest, but I'll just point out a few things. So first of all, I think the most practical implication of these requests for provisional measures is the workload of the court. So provisional measures have priority over all other cases. That's in Article 74 of the Rules of Court. So every time a request is filed, it pushes back all other cases on the docket, and that causes delays and creates, of course, additional workload for the court. And in some of these cases, like Armenia, Azerbaijan, or South Africa v. Israel, there are multiple requests for provisional measures, and these keep taking precedence over all other issues. And another, of course, wider issue which relates to these issues is the court being asked to micromanage a conflict which is ongoing. But that's a wider, substantial issue. Now, I'll add to that something that we all know is that the UN is strapped for cash very, very significantly. So there is a question whether this additional workload of incidental proceedings, incidental to the main case, create a strain on the court, which already has a very stretched budget. Of course, you can say, on the other hand, that these provisional measures, that this phase and these cases are as important as any other. On the other hand, the question is, if the main purpose of these cases are the provisional measures phase, for example, to highlight, as Amir said, a certain dispute that's been forgotten or there's no other recourse, whether this is the best way for the court to use its resources, particularly in cases where they know the provisional measures won't be implemented. On substance, I think that with the growing jurisprudence on provisional measures, one would expect more clarity as to the court's doctrine of provisional measures, and we might be seeing some of that on the margins. But given the difficulty and highly sensitive subject matter of some of these cases, I don't think we've been seeing the application or the court's application of its provisional measures as clarifying the issues, but rather making them even more opaque. For example, on the issue of plausibility. And considering the difficulty and the political sensitivities around these cases, we'll probably get more of that before we see more clarity. And just to add something, sort of piggybacking to what Cecilia was talking about, I think when we're talking about armed conflicts in particular, but it doesn't have to be armed conflict, but it can be any conflict, which really has to do with the most basic interests of any state. The compliance costs of compliance with provisional measures, for example, to stop fighting, whether it's Ukraine v. Russia, the whole Armenia-Azerbaijan issue, South Africa v. Israel, the odds of a party complying are very, very low to begin with, because their interests lay somewhere else. And I think that's just a fact the court needs to recognize. Whether that's fair or not is another issue. But I think that's something the court definitely has to consider when it's looking at whether to issue provisional measures.
Thank you for that. And I kind of want to piggyback on your point about, are states looking for the court to micromanage their conflicts? And it leads nicely into my next question to Amir. I mean, in what ways do you think that this type of involvement of states from the global south, as you've defined the global south, in turning to provisional measures, altered their own strategies in international litigation? I mean, is it just looking for the court to micromanage their conflicts? Are there other considerations? What are your thoughts?
Well, I definitely agree with a lot of the points that have been made about sort of the pitfalls of having maybe too much recourse to the court, whether it's because of overloading the court, which has a limited bandwidth, and I think that we've seen that a lot with personally had experience with that with the Armenia-Azerbaijan cases, where there's sort of only so much you can ask of an institution composed of 15 individuals, mostly at retirement age, who have with them 2 lawyers each, and not all the resources of the world. So there are limits, and there's of course the issue of compliance or non-compliance. But that being said, I think there are still some strategies and advantages of seeking provisional measures that mostly global South states have been developing and pursuing recently. We've discussed some of them. It's calling attention to a situation that could be in the media, it could be on the political plane. Oftentimes these provisional measures will generate discussion and statements by states in other fora, whether it's the Security Council, General Assembly, bodies of the European Union, Council of Europe, etc. So they do provide really sort of a temperature check of international law on certain issues that a state can then take with it wherever it uses international law and say, here's what I can tell you has been found by the International Court of Justice about what Israel is doing, what Azerbaijan is doing, what Russia is doing, etc. And that can create a deterrent effect for certain bad actors. Sometimes just the effect of a state having to come into court and explain itself can have some impact on the way that it's behaving. Putting conduct under a microscope, I think we really saw that with the Armenia-Azerbaijan cases, where there was the blockade of the Lachin corridor and of Nagorno-Karabakh, where there was, Azerbaijan was not permitting any civilian humanitarian traffic into Nagorno-Karabakh and was keeping it basically on an entire blockade and lockdown. You had a sort of pretext that was being put forward by Azerbaijan at the beginning, which is that there were these environmental protests, and it was completely spontaneous and natural, and that was just what was causing the road to be blocked. But putting that proposition under the microscope in front of the court, where there had to be evidence, there were PowerPoints, there was analysis, there were exhibits, it really sort of, in my view, I'm of course biased, but it blew that narrative out of the water, I think. And it did so in a way that just general media attention of this type of thing, particularly a conflict that isn't center stage, maybe would not have happened. Just one other example of provisional measures sort of succeeding strategically, and I think this happens even if the measures themselves aren't granted. Nicaragua versus Germany. So I think everyone is sort of aware of that request made with regard to the supply of arms, among other things, to Israel. I think it's important to note that it wasn't just Germany that was put on notice of a potential dispute. It was also Canada and the Netherlands. I think perhaps partly as a result of that initiative, we saw some changes in behavior on behalf of Canada with regard to arms exports. There was a decision by a Hague District Court suspending transfer of F-16 parts to Israel. And Germany itself, I'd say one of the reasons it was able to defeat that request for provisional measures was by sort of showing that, well, actually, we're not really sending anything now. Anything we sent very recently was de minimis. We don't have plans to send more at the moment. We're reviewing, we're doing this, etc. And I think that in and of itself achieved, in a way, the goal of Nicaragua and, let's say, the global South of a chilling effect on arms exports to Israel by global North states that care about the perception of their compliance with international law. So that was, I think, a strategic success in the face of a on-paper failure. And I won't go into any more, but we've touched on Ukraine, Russia, how there can be a backfire from shoehorning a dispute into an instrument that might not fit exactly. But I think it's a balancing exercise between those longer term goals and the shorter term effects you're trying to achieve.
Thank you, Amir. And it's really interesting because the signaling effect that a provisional measures order or not in the case of Nicaragua and Germany can have, and earlier, Cecily, what you said about naming and shaming before the General Assembly, for example, naming and shaming type technique, kind of leads me into a question for you, Ona, which is more courtside, basically. I mean, in what ways do you think, considering these two elements, could the ICJ's role be clarified or expanded to better handle the complexities of provisional measures orders in these types of politically charged cases?
Well, that's an interesting question. I mean, I've been listening to the comments with a lot of interest. I mean, I think that this conversation brings out some ways that are not always appreciated of the impact that an ICJ, not just decision, but hearing of the issues and airing of the issues and arguing about the issues and providing what feels like an objective forum in which to make arguments in a legal register as opposed to a political register, how important that is. And I mean, you're asking about how the ICJ's mandate could be clarified. I'm not sure that there's an easy answer to that. I mean, I think that part of the way in which we're going to see that evolve is going to be how the court responds to these requests, and then therefore what kinds of incentives that creates for states to either continue bringing these cases or not bringing these cases. So what do they perceive as the value or benefit of moving forward with these cases? And I think what's so important about the comments that both Cicely and Amir made and Iran is that the impact is far broader and far more interesting than I think is sometimes appreciated. And that even if you don't necessarily get the order that you want immediately, the fact that you're forcing the other side to articulate the legal reasons for why it is or isn't in compliance with international law, or generally they're obviously arguing why they're in compliance with international law, that itself has an impact, even if the case doesn't succeed in the sort of traditional sense. And so I think exactly right that, the Nicaragua v. Germany case, just the filing of that really put states on notice that they need to be thinking carefully about their own potential complicity in the courts in what's happening in Israel. And I think the connection of that to the South Africa v. Israel case and also to the advisory opinion on the status of Palestine the combination of these three together, I think, really put states on notice that they're responsible. It's not just, sort of an Israel-Gaza issue. It's all states have a responsibility to live up to their own obligations, not to aid and assist in unlawful action through providing arms, and that itself can have an impact. I think what the court is going to have to try to manage, though, is, how much is it willing to play that role? And how much, it may, if there are continuing to be large numbers of these provisional measures requests, I think there is going to have to be a way of managing the court's workflow, because it can't be constantly pushing back its merits decisions because it's getting hit with all of these provisional measures requests. And it either is going to have to reprioritize, or it's going to need to have more resources. And that then is going to become a question for the UN as to whether it's willing to dedicate more resources to the ICJ, and whether it sees this role the ICJ is playing as a valuable one. I as a lawyer, as an international lawyer, I think it's critically important. And I think that the court needs more resources to manage the workflow that it's now facing. I also think, and I'll kind of put my cards on the table, I think this role is so important because having a place where states can make the argument that their legal rights are being violated and force the other side to respond is critical to the success and to the health of the global legal order. To have these violations being taking place and having no place to be able to air them is so critically important. I think Amir's point about the way in which the Global South is using the court this way, this is exactly what it should be doing. This is exactly the role that the court should be playing, is giving a place for people to be able to make these legal arguments. And to air arguments that are otherwise not getting attention and otherwise not going to be the center of the Security Council's agenda, but are extraordinarily important to the health of the legal order. So, yeah, so my answer would be, I do think that this is going to be something that is going to be both a kind of political and legal issue. I think for the court, only so much of it is in the court's control. Some of it is just how it's responding to these requests. But also ultimately, it's going to be up to the political bodies to determine if they're willing to actually back up the court by providing the resources that it needs to be able to manage this much more robust role that the court is playing in these critically important disputes. And last thing I'll just say is, it's much better for people to be doing law than working this out in conflict. And so these are. I think it's important to remember that when states are bringing cases to the court and making their legal arguments and arguing that their legal rights are being violated, it's showing a real faith in the system. And it's showing a commitment to law and the global legal order that I think is really hopeful. And I think it's up to the court and up to the United Nations to respond to that by providing the resources that are necessary to actually be able to live up to this role. Because if it doesn't, and if it takes forever for these decisions come out, and if the court really backs away from playing this role, what are the alternatives? What kind of message is that sending about the importance of these legal of these laws that these states are arguing are being violated? So I think this is a critically important role, and I hope that there will be more support so that the court is able to continue to play this role, and in fact that potentially even expand it.
Thanks, Ona. It kind of leads me to a follow-up question to you again, actually, because you talked about the critical role of the court and the good that can come out of this critical role. And I guess the flip side of that is, can bad come out of this critical role? I mean, in cases involving the use of force, again, it's the example we have at hand. I mean, could the ICJ's issuance of provisional measures actually escalate conflicts on the ground? And how can the courts address this risk?
Yeah, that's a great question. This is a question not just about the court, but it's a question about international law more generally, right? And it's a question about what role does law play in times of conflict. And I think the court is sitting at the kind of fulcrum of this debate right now about what is the place of law in conflict today. I mean, we're seeing an extraordinary erosion, or at least challenge to the prohibition on use of force, which is at the core of the UN Charter, Article 2.4. I mean, Russia's invasion of Ukraine is just an obvious, like, all-out assault on that fundamental underlying principle of the international legal order. And Ukraine is trying to fight back with law, as well as obviously with force. And in many ways, that's been very successful. Both, part of its strategy is the ICJ, but it's not limited to the ICJ. I mean, it's sought resolutions Security Council, which have been vetoed and then have gone to the General Assembly. And there have been a series of General Assembly decisions basically saying, yes, you're right, this is illegal. And the invasion is illegal and it's unlawful under Article 2.4. And that then has set the stage for a whole host of third-party actions of economic sanctions, arming and supporting Ukraine, providing weapons, providing financial support and the like. So law is playing a really critical role in these conflicts. One might say you're escalating the conflict. I would say, you're defending this critically important principle of the international legal order. Yes, you're allowing Ukraine to defend itself, but the alternatives that is that Russia succeeds and we have, a massive conquest of territory in Europe, the first significant, the second, Crimea being the first significant conquest of territory in Europe since World War II, which is really the beginning of the end of the modern legal order. So, I think that this role is critically important, but it's the ICJ is not acting in isolation. It's part of a broader, international legal order, and that order is under stress in deep and fundamental ways. It's not just the use of force, but it's also the way in which wars are being conducted. I mean, the South Africa v. Israel case is being brought under the Genocide Convention because that's the only way in which they can get into the ICJ. They can't bring claims under the Geneva Conventions. Some of that is now obviously playing out in the International Criminal Court with the war crimes, the requests for arrest warrants against Netanyahu and Gallant. So we're seeing law being kind of brought into these conflicts, but it's in response to what are at least perceived as, and in many cases I think really are, massive challenges to these fundamental principles of international law in the post-war era. And the courts are kind of like one of the pieces of this much bigger puzzle. And we're sort of seeing, so we can't see it in isolation. And do they make it worse? I mean, I as a believer in law, I don't think so, because I think the alternative is we give up on law. And if we give up on the law, then, I think we go back to the pre-war era where things were much more bloody and violent. And I think the world was much worse off. And so I don't think that's the answer, but I don't think the court can do it alone.
Absolutely. A piece of the puzzle, I liked how you put it, that we're operating in a broader system. And it brings me to you, Cecily, with safeguards, basically, to protect our broader system. I mean, what safeguards do you believe are necessary to ensure that in the context of provisional measures, these aren't perceived just as mere tools to advance political agendas,
I have a very technical answer to this question, because the court doesn't really have that much to work with besides its rules on jurisdiction and admissibility, right? So if the court thinks that the questions put before it don't actually concern a legal dispute, then it can of course rely on its jurisdictional rules to not answer or not provide an order. And of course, occasionally we do see the court doing that, like in the Marshall Islands cases. And of course, then that the court opens itself up to criticism about taking an overly formalistic or narrow approach to political questions. And that clashes with expectations that are put upon or thrust upon the court about what it should be saying on major issues like nuclear weapons, even if those expectations might be unrealistic from the start. And in terms of how the court then deals with the political context, usually it does so in a very, I think, subtle and also limited fashion by including those paragraphs in between asterisks, which acknowledge all of the issues sometimes that all of the key issues that fall outside of its subject matter jurisdiction. Of course, there are also rules on admissibility that the court can use to ensure that it's dealing with the appropriate set of legal issues. But in recent years, the issue of standing and the way that it's been interpreted in Belgium, Senegal, and confirmed in the Gambia, Myanmar case, have had the effect of course, opening up the kinds of cases that the court can receive, and opening the court up to cases with a much stronger political tint. So, in other words, I think the safeguards, the bumpers that the court can have recourse to are very limited, and go back to the rules on jurisdiction and admissibility.
Yeah, thank you, Cecily, for that. And it kind of brings me to our last question before we run out of time, to all of you panelists, and it echoes a lot of the comments you've made throughout the last hour. So very simply, do you believe this increase in reliance on provisional measures kind of reflects a growing tendency to use international adjudication? And if so, what does this mean for the future of international dispute resolution?
I'll just say very briefly, I mean, my sense is yes. But will this be sort of the high water mark? And will states decide that they're not getting what they're hoping for out of the court, and therefore, confidence collapses? That's still to be seen. But I mean, I do think that the court's development of erga omnes partes standing has really opened up some new space for parties to bring suit, and the sort of broader idea, and this is something that Amir mentioned, the broader sense that the court is open to not only the states that are directly harmed by the conduct, but third states who see critical legal obligations being violated, bringing the case, opens up a lot of space for additional states to bring suit, and they've been using that. And I think, I mean, my sense is that that's likely to continue. But if it seems like this is just going nowhere, and courts are not getting, and states are not getting anything out of this, and they're spending a lot of time and energy on it, and it's ultimately leading to disappointment, then that could very well change.
Just to add quickly to what Oona said, I think if we want to think about the future, we kind of have to look a little bit back to where we got this system from. And when states sat down to draft the PCIJ statute, they were faced with this question of, are we going to have a sort of compulsory universal jurisdiction, a world court that can hear any dispute of international law, or are we going to have it be based upon, the narrow consent of states in individual circumstances? Of course, they opted for the latter solution. But query whether any sort of legal system that's going to function or be respected or have a degree of legitimacy needs a sort of universal supervision, and whether these provisional measures trends combined with erga omnes, combined with the advisory opinions, is a sort of natural workaround for that obstacle that is baked into the system, and whether maybe we should be embracing that. At least that's my view.
So we've opened the Q&A up. If any, we have a minute left. Apologies for that. But if anyone wants to ask any questions, please do write them into the chat box. I know I have a question for Iran. I mean, how do you think the demand, as this demand kind of grows and we're unsure as to which direction it's going to go in, what reforms or kind of procedural adjustments do you think are necessary to ensure that provisional measures continue to serve their intended purpose?
Sure, just very, very briefly. I think we haven't really discussed the procedures around provisional measures, but I'll highlight two problems that I think exist. One is the response time given to the respondent to reply to a request of provisional measures. The applicant might be working on the request for weeks, if not months. The respondent has limited time to react. Now, obviously, provisional measures are a matter of urgency, but as Amir noted, the court is not really built anyway to respond within hours or days like the Security Council. And then on the other hand, right now, the practice of the court is to have one round of oral hearings, which in a way is unfair to the applicant because the applicant does not get an opportunity to respond to whatever the respondent brings to the court. On substance, I will echo something that Cicely said, and that's that I think what the court might consider is taking a closer look at the provisional measures phase of its jurisdiction in any particular case. So to go beyond what it does now in terms of prima facie jurisdiction, and that way perhaps to avoid certain expectations like in Georgia v. Russia, Ukraine v. Russia, and so on. I'll just add one last thing that sort of to echo and agree. So Una mentioned the idea that we can float and have arguments about international law in a public forum. For whatever it's worth, you know, Russia didn't appear to the provisional measures. They did appear for the preliminary objections phase and made arguments and won on them. How that helps the rest of the state of the world, I don't know, but it does mean that they took the court seriously. And finally, just to sort of reinforce something that Amir said, the request for provisional measures does have effect beyond the provisional measures. And many times what we see is sort of states, the respondents taking on unilateral obligations in order for the court not to issue provisional measures. So Timor-Leste v. Australia, essentially Australia agreeing to give Timor-Leste more or less what it wants. Same thing now with Mexico v. Ecuador and so on. So in that sense, provisional measures also have an effect beyond the order itself.
Thank you very much for that answer, Iran. And with that, our time is up. We're 2 minutes over, actually. So I wanted to thank the audience and this panelists especially for this great discussion this morning on provisional measures. And I hope you know, we have a part 2 to this discussion, seeing how the rest of the year develops.
Thank you.